I'm Ben Meiselas from the MeidasTouch network, and I want to discuss how special counsel Jack Smith's reply brief proves his tactical genius that I have been talking about here on the MeidasTouch network. Jack Smith was ready to file this reply brief in under an hour after Judge Chutkan granted leave to file this reply brief in the first instance. So this reply was ready. Jack Smith had the arguments ready. In fact, I would say Jack Smith had the arguments ready to go months and months and months ago when a tactical decision was made by Jack Smith what to charge Donald Trump with and what not to charge Donald Trump with. And it must have been a very difficult decision for special counsel Jack Smith, who arguably could have charged Donald Trump and brought before the grand jury in Washington, D.C. for crimes committed by Trump relating to the 2020 election and the January 6th insurrection, thousands of separate counts that could have been brought against Donald Trump. Heck, Donald Trump could have been charged for hundreds of counts alone relating to financial crimes attendant to the political action organizations that Trump has used, which we know special counsel Jack Smith has been criminally investigating and still has been criminally investigating before the Washington, D.C. grand jury. Also, special counsel Jack Smith had to decide who to charge and who not to charge. And while you have a number of unindicted co-conspirators listed in the criminal case against Donald Trump brought in Washington, D.C. relating to the January 6th insurrection and the 2020 elections, only Donald Trump was criminally charged. And the reason for that is special counsel Jack Smith wanted to be surgical. He knew, he was thinking multiple steps ahead, that Donald Trump and Trump's lawyers were going to cite other January 6th related cases, including those involving the Oath Keepers, those involving the Proud Boys, that took far longer to go to trial than the January 2nd, 2024 date that special counsel Jack Smith is asking for. But when a trial-setting conference would take place, and there is one scheduled for August 28th, special counsel Jack Smith wanted to go to the federal judge, in this case it's assigned to federal judge Tanya Chutkan, and say this case against Donald Trump is different than the case against the Proud Boys, where there were multiple defendants. This is different than the Oath Keepers, where there was multiple defendants. Judge, this is a simple case involving 4 counts and 4 counts only, and one criminal defendant in Donald Trump, and that the vast majority of documents that are at issue in discovery include documents that are already in the possession, custody, and control of Donald Trump. So when special counsel Jack Smith brought this indictment that was voted on by the Washington, D.C. grand jury, he didn't just have the indictment ready to go. He had the whole plan mapped out, how this case goes to trial in early 2024 by making decisions not to charge anyone other than Donald Trump, as well as to ensure that there were only 4 counts brought and not bring all of the other financial related crimes in this one, but still investigate those, which could still be subject to another criminal case in the future. And look, what did Donald Trump's lawyers argue? The exact thing that Jack Smith knew they were going to argue. Hey, these other January 6 cases took longer than a year. These other cases involving similar criminal statutes took longer than a year. Jack Smith was ready. Those cases involved superseding indictments, multiple co-defendants, and had, issues and that were far different and made it more complex. This is not a complex case, Judge Tanya Chutkan. So you see this in the reply brief that Jack Smith filed. This reply brief to Donald Trump's opposition to Jack Smith requesting a January 6, 2024 trial date, I bet you this reply brief was pretty much written months ago. So when Judge Tanya Chutkan granted Jack Smith's team the ability to file this. This was ready to go. Make a few adaptions based on what Donald Trump wrote. The judge ordered it be 6 pages, so make it a 6-page reply brief. But otherwise, they filed this thing right away. And take a look at the arguments that they've made, and you'll see how this went down. So government's reply brief to defendant's response in opposition to government's proposed trial calendar. The government is requesting January 2nd, 2024. And it says the following. In service of a proposed trial date in 2026 that would deny the public its right to a speedy trial, defendant Donald Trump cites inopposite statistics, means inapplicable, doesn't apply here, and cases, overstates the amount of new non-duplicative discovery, and exaggerates the challenges of reviewing it effectively. For the reasons below, neither discovery nor any other factor raised by defense impedes a fair trial on the schedule proposed by the government. Then they go to the cases cited by Trump. Now, if Jack Smith brought this against multiple co-defendants, if Jack Smith brought this as well with multiple more charges, especially financial crimes where you'd have to have forensic auditors and accountants and numerous experts, financial cases take a long time to go to trial, sometimes years. Then the statistics that Donald Trump would be citing may be applicable. But Jack Smith didn't want that to happen months ago, so narrowed the claims, narrowed the criminal counts being brought. So then Jack Smith can say, yeah, the defendant's references to these other statistics and January 6 cases, they overlook important underlying facts and context. First, the defendant cites the median time from commencement to termination for jury trials of Section 371 charges, 29.4 months. So Trump's saying the median time these January 6 cases take to go to trial is 29.4 months, which is more than 2 years. But Jack Smith goes, but what Trump is not explaining is that if you look at the time that Trump is citing, that includes cases through the completion of sentencing, not when trial actually starts. That means that it includes the time required for jury selection, trial, verdict, and several months or more afterwards before sentencing and final judgment. The question here is, when is it appropriate to start trial in this case? And statistics regarding the length of time from indictment to sentencing in other Section 371 cases have no bearing on that decision. Second, the data cited by the defendant spans October 21 through September 2022, when federal courts still had a COVID-19 backlog, so this small sample is inapplicable. Also, the defendants listed January 6 cases also omit important details and context. He fails, for instance, to mention that in one case he cites, disposition was delayed because, among other reasons, litigation over pretrial detention, a superseding indictment, and plea negotiation. So think about that. Pre-trial detention. So one of the things that I think Donald Trump is trying to do here, and many have speculated, is Donald Trump trying to get arrested and violate the terms of his conditions for bond so that all of those issues can be litigated. If Donald Trump violates it and then there's all of this briefing on pretrial detention, that could distract from when the trial date is. And so here Jack Smith is saying there's all this litigation in these other cases cited by Trump over pretrial detention where one of the defendants went to jail because they were violating the terms of bond or they were in jail pending disposition of the case. So for many people saying throw him in jail, well, that can actually delay final disposition. And Jack Smith recognizes that as well. And then it says, all of the defendants' other cited cases included multiple co-defendants with as many as 17 co-defendants and multiple superseding indictments. There's this case with a 5th superseding indictment. The court should set these inopposite comparisons aside when weighing the individual factors here under the Speedy Trial Act. So do you see the brilliance here of what Jack Smith is doing? And I want you to understand the context also about, you may say, why isn't Jack Smith asking for pretrial detention? Trump's harassing people. That's clear violation because Jack Smith wants to go to trial. And litigating pretrial detention could cause delay, and all these other factors could cause delay. And Jack Smith is razor focused on the most efficient path to trying this case, even if that means pulling back on some of the criminal charges. Ultimately, at the end of the day, the result of this case could and should be Donald Trump in prison for the rest of his life. So let's get to that trial. I think Jack Smith realizes the import of that. I'm Ben Meiselas from the MeidasTouch Network. Go to MeidasTouch.com for more breaking news, all things MeidasTouch. Also, check us out as well. Wherever you get audio podcasts, subscribe to the MeidasTouch podcast and have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.